if you read the manifesto, there was no mention of funding in the manifesto. It says, establish an act of parliament, an office of the special prosecutor who will be independent of the executive to investigate and prosecute certain categories of cases and allegations of corruption and other criminal wrongdoing, including those involving alleged violations of the Public Procurement Act and cases of implicating political office holders and politicians. So no indication of funding challenge or anything.
So the funding is bonus then, right?
I think that certain impressions have to be corrected. I do not think that Office of Special Prosecutor was set up without funding. I do not think that the resources were not made available for the discharge of his functions. Indeed, various resources in various forms, a house allocated to him, office equipped as soon as possible after he was appointed, a deputy was appointed, and some staff were also made available to him.
So should he have been able to bring some cases?
But I'm saying that indeed, you see, earlier on, Mr. Bushi alluded to the absence of an ally. In my humble view, I do not think that the enactment of an ally is necessary before the conduct of prosecution by the officer, by a special prosecutor can be undertaken. I do not think so at all. The special prosecutor does not derive his prosecutorial powers from an ally. It derives his prosecutorial powers from the act which set up the office. And Section 4 gave the mandate of the office and the broad area of crimes that he was empowered to prosecute was to set out in the act. Now, the crimes that he was supposed to prosecute itself were not set out in the act itself. They were already even existing. Corruption were already prescribed for by law. So the various offenses had already been prescribed for by law. So clearly, the passage or enactment of an ally was not what was necessary for the undertaking of prosecution. And so clearly, we cannot hinge the freedom of the special prosecutor to prosecute on the absence of an ally. And indeed, if you look at the ally is not supposed to regulate how you're supposed to prosecute. Regulation Section 78 of the Act sets out what the ally was supposed to be. And it says out that you're supposed to prescribe the manner for tracing tainted property, prescribe a procedure for declaration of property and income, prescribe a procedure for the seizure of tainted property, prescribe a procedure that for the management of assets seized under this Act. So there's nothing in the regulations that itself will set the framework for the conduct of prosecution. Prosecution is done every day. It's done in accordance with the Criminal Offences Act and the Criminal Procedure Act. So I do not think we can.
So I guess my question was: should he have done
even
some cases by now?
Even that ally is before Parliament now, and it's been fast-tracked. I believe you are aware. And as I told you, enough resources have also been made further available to him in the 2019 budget. So there has been the provision of every opportunity at all. And I do not want the special prosecutor is supposed to be independent, and I therefore will not answer that question. Why he has not prosecuted? I cannot answer that question, and I'm not supposed to answer that question. Because, and he's also, if you look at it, he's also to rely on the investigative bodies of state. So maybe leave at that.
But you do feel he's
for corruption, I do not think that when we look at corruption, we should even just look at it narrowly within the compass of the offense of bribery and corruption. Yes. We should look at various measures of public officers and law, which impinge on infractions of law and also even actually amount to even pillage of state property. Now, just before we came, in December 2016, I believe you're aware that resources constituting about 60% of the nation's known bauxite resources were handed over to a company owned by the president, owned by the brother of the president, in violation of due process, in violation of all the regulations under the Minerals and Mining Act. And what did we do? When we came, we promptly took action. And indeed, the institution of that action against Esteem Kubik, to me, was very significant. It went to show that a person cannot be in office and then subvert procedures and which amount to allocation of resources available to the whole state to a company either owned by himself or his brother or his relatives.
Should someone have been prosecuted for that?
It's something that we will definitely look at. And indeed, it's also worthy to know that even as of now, the person is still in the Supreme Court trying to, even today went to court, Supreme Court, trying to reverse some orders made by the High Court against him. And I'm saying that you do not find examples of such conduct in this administration. On no account will you find that President Akufo-Addo will violate procedures procedures to allocate resources to the state, whether mineral resources or forestry resources, to a company owned by himself or his brother. It will never happen at all. And also, we knew about the Woyome case. The Woyome case also represents one important case in the fight against impunity, as far as I'm concerned, where procedures, in fact, payment can be made, payment amounting to about 25 million euros at that time can be made to an individual who does not, under any circumstance, have any contract.
Right.
We have also
I want us to refocus.
For 2 years, you haven't been able to retrieve the money.
Good. No, but that one, yes, clearly, we are almost at the end, at the tail end of that struggle. And indeed, it's also because we would have finished long ago, but for the fact that the first 6 months of this year, the judge responsible for it was also responsible for the conduct of the Charlotte Osei trial. He himself even said it in court, and for that matter, there was no court sitting at all. And since he came back in October, between October and now, there have been all manner of applications by UT Bank and whatever, claiming the same property. And we have dealt with all of that. The trial has concluded. I'm sure the ruling will be given in no time. And within a matter of months,
I would like us to
we'll come to the end of that struggle.
Okay. I would like us to refocus on the manifesto
and
itself.
I'm coming. We also have passed a number of laws. I can also allude to the Witness Protection Act, which has been passed. And there's also in the works the Code of Conduct of Public Officers, which sets out a better regime for the rendering of account by public officers, as well as asset declaration, whatever. Yeah. These are very significant.
You beat me to.
Just by the way, Mr. Deputy Minister, earlier in other panel discussion, I think that the point was made that we have all the beautiful laws, but enforcement is another thing. You mentioned the witness protection law, and in your own manifesto, you speak about amending sections of the Criminal Act 1960, Act 29, particularly Section 1, Section 3, Section 151, and Section 239 to 257 to criminalize corruption.
Yes,
but have you done it?
Corruption, to make criminal. To make corruption a felony.
A felony, okay, a felony. To make it a felony.
So corruption is already a crime. But even in respect of that one, it's significant to know that even though in theory it's not categorized as a misdemeanor, the punishment for it is more than what a misdemeanor will attract. The punishment for corruption is a maximum 25 years under the law.
Is that why you haven't?
But you
is that
yourself,
why you haven't bothered to fulfill the promise?
No. I'm saying that even in the absence of the introduction of a bill to Parliament to make corruption, in theory, a felony, the punishment for corruption is akin to a felony.
So why did you make the promise?
No, but I'm not saying we're not going to do it. I'm saying that can be done if you just wanted to bring it in line with the punishment. The punishment for corruption now is 25 years. And all these crimes that we're investigating, people talk about high-level corruption and say they allude to the fact that they lead to a failure of the Attorney General to prosecute high crime, corruption of high public officers. Now, we was already in the pending the course of Ghana, the prosecution of Mr. Stephen Opuni. There's also the prosecution of the former board members of NCA and other offenses. So it cannot be entirely correct that there's actually the absence of corruption for high-ranking public officers.